I serve as the administrative role for the duly elected mayor and council. I do not set policy or direction for the city of Port Huron. I run the day-to-day operations for the mayor and council. I have 400 employees. We have an annual operating budget of $120 million, and we oversee 30,000 residents, and we provide drinking water to more than 60,000 people in St. Clair County. I was hesitant to come here today, as I do not want to be any part of a partisan political battle. I want to bring facts to this committee of events that actually transpired in the state of Michigan, because I believe that sunshine needs to be shed on what happened in Port Huron. In early March 2020, I began receiving briefings from Health Department, the media reports of the COVID-19 pandemic beginning to emerge across the United States and into the state of Michigan. We took this very seriously. In the city of Port Huron, we were one of the first municipalities to, I say, bug out, where we first issued the work from home order and sent our employees home. We were the first municipality in St. Clair County to do that. We invested hundreds of thousands of dollars in remote work technology. We invested over $100,000 in microbial disinfection spraying. The walls of City Hall had to be repainted because the amount of microbial spraying we did actually took the finish off the wall. The varnish on my desk is physically destroyed from the amount of disinfection spraying we completed within the city of Port Huron. We worked tirelessly to obtain and acquire necessary PPE for our first responders and essential workers so that they could continue to deliver the core services to our residents: public safety, police, fire, safe drinking water. That is critically important. Government did not get to stop. We invested more than $100,000 in structural changes to City Hall, meaning building glass, putting safety partitions up, separating workstations, creating a safe environment. When we began to bring workers back from furlough, the city of Port Huron was the first municipality in St. Clair County to develop a response and preparedness plan. We actually worked with our health director to write this plan. It was such a good plan that as of today, dozens of municipalities across the state of Michigan have adopted our exact same plan and strategy. We took COVID-19 very seriously. My job, first and foremost, is the welfare and safety of my residents and employees, and I took that very seriously. I have the blessing of living in the community I get to serve. So on July 21st, I was at home having a bologna sandwich for lunch when one of my staffers called and said, "Mr. Freed, MIOSHA is here. They want to speak with you." And I said, "Fine." I said, "That's absolutely fine." I said, give them free access. I gave the director, give the inspector free access to any part of the building. He can do whatever he wants. I'm going to finish my bologna sandwich, and I'll be there in about 30 minutes. We are a collective bargaining city. We have 6 collective bargaining groups, and when MIOSHA visits and holds an evidentiary hearing, the initial hearing, they all get invited. So I came back from lunch, and in my office was representatives from different union groups. There were command staff from the police department. There was the POAM representatives. There was the firefighter association was there. There was about 8 or 9 people in the room. Seasoned investigators from the detectives bureaus were there, all listening in on what had happened. The MIOSHA inspector, Matthew Hartman, came into my office and he says, "Mr. Freed, we have been submitted with a report that you do not have a response and preparedness plan in place." Because we're in the middle of an ongoing COVID pandemic, I literally had the file folder over my shoulder. And I turned around and I grabbed that file folder and I handed it to the inspector. I said, "You have been misinformed. Here is a copy of our response and preparedness plan." He says, "Mr. Freed, it's been alleged that you are not providing PPE to your staff." And I said, "Well, which door did you come in?" I said, "Actually, it doesn't matter. At every single entrance into City Hall, whether it be employee entrance or public entrances, there were tables set up with hand sanitizer and masks and signature placards on COVID-19 precautions as part of our response and preparedness plan." I said, "Sir, did you not see the tables of PPE everywhere?" He's like, "Well, I didn't notice them." I said, "Well, they're there." He goes, "Well, we also have complaints that employees don't have to wear masks. It's personal preference." I said, "Well, who said that?" He goes, "It doesn't matter." I said, "Well, when you asked the employee, where were they sitting?" He goes, "Well, does it matter?" And I go, with all due respect, Mr. Hartman, it absolutely does matter. As if you remember, and this is the fog of war here, we're going back almost 2 years, when the executive orders began rolling out, it wasn't that you had to wear a mask, everyone indoors. You only had to wear a mask at one point if you were in shared spaces, and at one point if you were within 6 feet, if your workstation was within 6 feet. If your workstation was more than 6 feet away from another workstation, it was your personal preference to not wear a mask. So I asked, what day and where at did this employee allege this to happen? Well, I didn't ask those questions. He goes, Mr. Freed, it has been alleged that you have been roaming the building without wearing a mask. At that point, one of my detectives spoke up and said, I've never seen Mr. Freed roam the building without a mask. I said, well, I take that very seriously. When and where was it alleged I wasn't wearing a mask? He's like, I didn't ask that question. That's all right, Mr. Hartman. If you look in my office and through all the building, we have invested hundreds of thousands of dollars into HD video security systems. Please name the date and times you would like me to submit video footage of this facility. I'll give you any video footage you want. He said, I don't want that. I asked Mr. Hartman, I said, in your inspection today, and this is important to note, that the MIOSHA inspectors, they don't announce their visits, nor should they. You don't want to prepare for something like that. You want an honest assessment. He showed up unannounced, without a badge or a uniform, which is normal. You would expect that. When you're doing an investigation, you don't announce you're coming, and I mean, that's reasonable. I said, Mr. Hartman, you've been roaming the building. You've had free access to go wherever you want. Have you observed any violation today? And he said, no, I have not. I said, well, I appreciate this. This is, a nice chat. You have a nice day. And he left my office. I spoke with my staff briefly. We thought, well, that was a big nothing burger. Did the inspection, nothing happened. On August 3rd, Mr. Hartman held a conference call. He was remote, and the collective bargaining groups were again back in my office to observe the phone call. And I should say, the corresponding days after that, my staff and I exchanged many emails with Mr. Hartman providing additional documentation. I provided MIOSHA the invoices for the more than $100,000 of microbial cleaning. I provided them invoices for the PPE. I provided them copies of all of our policies and plans. I provided all these as evidence to MIOSHA. He emailed my staff the day after, and this is a critical piece of email. He says, currently, MIOSHA is enforcing the requirements contained in Executive Order 2020-145 that was signed on July 9th. He made it very clear to my staff that he was enforcing the executive order. As you will know, this email runs counter to the Court of Claims order in late June stating that MIOSHA cannot use the executive orders as a benchmark for a general duty violation. If MIOSHA wanted to implement COVID-19 rules, they needed to promulgate emergency rules via the Administrative Procedures Act. They did not do that until November 2020. So the Court of Claims has ruled MIOSHA cannot go around the state issuing general duty violations based on the executive orders. They must promulgate rules. This is a critical email stating the intent of MIOSHA was to enforce the executive orders. Nevertheless, we weren't too worried about this because there was no violation. He openly admitted he saw no violation. That's why we were surprised on August 3rd during a conference call. He informed us that he would be citing the city of Port Huron with the most egregious, serious violation MIOSHA can give under general duty and issuing us a $6,300 fine. I was pretty upset over this. I asked him, how can you do this? You said you didn't see any violation. You produced no evidence of violation. We offered you documents, video footage. We've offered you everything to show that we are innocent. He wrote, I have a general feeling that you guys were slacking off. Now, that may sound like a remarkable, unbelievable quote. That is why I will also submit to the committee as evidence today. He actually wrote it in his report. He actually wrote a report. The opening conference left Mr. Hartman with a general feeling that the city was essentially digressing from the efforts of managing and addressing the COVID-19 pandemic. No evidence, no observation, a general feeling. Mr. Chairman, committee members, I will submit that into the record. We thought, well, we're going to appeal this, right? There's a process in place. Clearly there's no evidence, and clearly we have an inspector who is a little bit over-aggressive here, and so we'll appeal. We'll follow. I believe in processes. I'm an administrator. I'm not political. I believe in processes and administrative process, and so I felt this will quickly be thrown out. Before we ever had a chance to appeal, before we ever had a chance to exercise the due process afforded to us, imagine if you're a staffer in the city of Port Huron in the middle of a pandemic, donning PPE, coming to work, subjecting yourself to exposure to COVID-19, doing everything right, and only to have a statewide press release sent from the Michigan State Police Emergency Operations Center publicly shaming us for being cited without any due process. When has a public press release from the Michigan State Police ever sent out MIOSHA citations? This was done for one purpose, and it was to degrade the professional reputations of the employees of the city of Port Huron. Ironically, this press release was set out on October 2nd, the same day the Michigan Supreme Court ruled the executive orders unconstitutional. I want to talk about the appeal. I want to talk about what measures we took, and then I want to talk about the discovery process when we began to prepare taking this to trial and the issuing of subpoenas to MIOSHA. We issued our appeal on October 6th, 4 days after the statewide press release. Our appeal was focused on a multifaceted approach, and this is complex, and so I want to take my time and explain this because it's a complex information I'm going to give here. First and foremost, we challenged that the citation was issued on faulty legal premises, meaning the Court of Claims has already said you cannot issue MIOSHA violations based on executive orders. You must promulgate emergency rules under the Administrative Procedures Act. That was not done. 2, the allegations were factually meritless. There was no evidence. They produced no evidence. There was nothing to say that this were true. And third, the Michigan Supreme Court ruled that the executive orders were unconstitutional. Based on his statement in the emails, we are enforcing the executive orders. And the Supreme Court throwing those executive orders out, MIOSHA should have immediately dismissed our case. There was no need for an appeal. The Supreme Court had made the decision. The shocking thing about this case is MIOSHA stubbornly refused to dismiss the case after the Supreme Court ruling. They came back and said, no, we issued you under a general duty violations. We were not enforcing the executive orders, which runs contrary to what was written and sent to the city of Port Huron. Whatever you think about the executive orders doesn't matter. The point is they're null and void, and this was written under the executive orders. MIOSHA almost immediately denied our appeal. So then the important thing is then they began offering me settlements. And the day Mr. Hartman informed me that he was going to cite me, he informed me on the phone, if you pay sooner than later, you may get a break. And I informed him we will never pay, ever, and we will never plead guilty to a citation we did not do. And so a settlement was offered for $3,000. If we pay $3,000, MIOSHA will dismiss this case. There's a business decision to be made for most businesses who get cited by MIOSHA. Is it worth the fight? And the truth is that the discovery process we engaged on, subpoenaing, issuing depositions, hiring a court transcriber to describe the depositions, costs us north of $15,000 to $20,000. It would have been cheaper to settle the MIOSHA violation, which is what most people do. However, my employees deserve to be respected and to have their reputations restored, professional reputations restored. So we challenge this. We began through the administrative law procedures to request hearings, and we began issuing lawful subpoenas to MIOSHA. We requested emails, documents, because the key was we were challenging the case based on the legal argument of whether it was done under general duty and whether it was done under the executive orders. So the internal communications and guidance from MIOSHA leadership to the inspector were key in determining the intent of writing the violation and what it was written under. And so we sought the emails and internal communications and documents from MIOSHA. What we received was kind of shocking. They responded back, it's just simply too cumbersome to provide these emails, therefore we won't be doing it. Too cumbersome. I am not that tech savvy. I use Microsoft Outlook, and I can easily go to my Microsoft Outlook search bar and type in MyOSHA, and every email and communication I've ever had with staff or MyOSHA comes right up. I can highlight, click, and drag into a folder. What we learned was that we didn't have really any emails or communications or notes, so we got the original citation and no corresponding documents. So we began issuing a subpoena that we were going to depose Mr. Hartman, and that deposition I have before me. I'm not going to go through the entire deposition. I will provide that into the record, but I want to release highlights of it because I think it portrays some disturbing conduct that is going on at MyOSHA. First and foremost, we requested the notes. We did not get them. So under oath, we asked Mr. Hartman about them. And I'm going to read answers and questions. The questions were posed by our city attorney, Todd Schouty. The answers were provided by Mr. Hartman, the inspector, who I remind you was sworn and under oath. Answer, this is on page 14. I think I just saw it recently in the last day or so. Okay, answer. Okay, if I scroll down and highlighted the section I wanted to ask you about. Answer, Question. So it references handwritten notes. And then it says that the original notes were not retained and are unavailable. Mr. Hartman, yes. Question. Did you prepare handwritten notes during the investigation of the city of Port Huron? Answer, yes. All right, is this correct, that those original handwritten notes were not retained? Correct. Question, and were they thrown away, any notes? Answer, I work out of my house, so I typically burn them, dispose of them. Question, okay, so if the notes were destroyed, then that's what you're saying. Answer, correct. We do not have the field notes, the investigative notes that were done on site, the discussions with staff, what he saw. We don't have those. So how do you have fair due process when a good chunk of the evidence is destroyed? Additionally, we requested emails, and this is where it gets critically important. On page 16 of the deposition, I want to read to you about the records. Remember, this is a division of LARA, and they have agency-specific records retention laws. In MyOSHA, all emails regarding a case are to be kept for 5 years under the agency-specific record retentions. 5 years. Question, are there any emails that you have sent or received regarding this case? Answer, not that I'm aware of. Question, for example, did you send any emails to your supervisor, Curtis Johnson, regarding this case? Answer, not since it was closed. Note, closure in their eyes is when the citation is issued, not when the due process has been completed. Before it was closed, sir, did you send any emails to your supervisor, Mr. Johnson? I can't recall specifically. Question, have you done any search of your emails to see what emails you sent Mr. Johnson, or what emails Mr. Johnson may have sent you regarding this case? Answer, after a case file has been closed and turned in, we get an email that says all electronic communications, handwritten notes, and everything that's not in the case file be deleted or destroyed. They get direction from MyOSHA leadership to destroy these communications in violation of the agency-specific record retention laws. So what? Have anything in the case, so I wouldn't have anything else. Question, so did you, after this case was closed, go into your email system and destroy the emails that were sent to you or your supervisor regarding this case? Answer, I believe I did. Question, and what was the subject of emails that you destroyed? It might have just been generic guidance. I couldn't tell you specifically. Generic guidance. That's what we were looking to obtain in our subpoena, to understand the reasoning for issuing and continuing to hold this citation after the Supreme Court ruled it unconstitutional. We further revisited this issue with Mr. Hartman further on in his deposition on page 157. All right, and the notes that you destroyed, when you destroyed those notes, you knew this case could go to litigation, correct? Answer, I suppose yes. Question, and you say you spoiled evidence or destroyed that evidence under a directive from MyOSHA, correct? There was an objection to form. He could answer. The answer, okay, I was following policy on what to do with the documentation, after the case was filed and been turned in and the citations have been issued. And that includes destroying anything that is not included in the case file. Mr. Chairman, committee members, the sworn testimony I hold here in my hand and I submit to you today as evidence demonstrates that the destruction of emails regarding the Port Huron case were not an isolated issue. This is a pervasive culture of concealment and destruction within MIOSHA. Moreover, this culture didn't just happen. It comes at the direction of MIOSHA leadership. This culture of destroying evidence and emails regarding a case before due process has been carried out robs and disenfranchises defendants, small business owners, and mom and pops of real due process. And I come to you today to shed light on this issue and to request change within MIOSHA. The case in Port Huron, the Supreme Court, whether the Court of Appeals or the executive orders, all that's irrelevant. If I turn to page 69, question. Now, this is to the inspector who came to Port Huron. Now, from what you saw firsthand with your own eyes, would you agree that it appeared to be that the city was attempting to comply with COVID-19 requirements? They had a COVID-19 response plan, they had PPE in place, and they had signs up, they had people wearing masks, and everyone you talked to had a mask, and it appeared they were generally attempting to follow the rules? Answer, I would agree with that. The inspector agreed with that. This case was dismissed because it was meritless and there was no evidence. I want to thank the professionals at the Attorney General's office. When the Attorney General's office reviewed the deposition and evidence, they immediately took action to dismiss this case. Those professionals recognized that this was meritless. So I thank the professionals in the Attorney General's office. The issue becomes is that the appeals process from within MIOSHA did not work. Mr. Hartman testified in the deposition under oath that when we put in an appeal challenging the facts of the case, his supervisor, Curtis Johnson, never asked him about it, never reviewed the evidence, just rubber stamped, denied the appeal. Anyone who took a look at the case knew it was meritless. So I thank the Attorney General's office. Lastly, I want to thank the employees of Port Huron. While unaccountable bureaucrats in Lansing were trying to tarnish their professional name, they continued to come to work under remarkable circumstances, donning PPE and working to the highest level of standards and excellence to deliver core services to our residents. Many of them had to go home and sleep in campers and pole barns in their garages to separate themselves from the dangers they encountered at work to their families at home. It cannot be underscored how impressive our workforce did. I know today that there are hundreds of employees in Port Huron, Michigan watching this hearing live today. And I want them to know that I am proud of them and that serving as their city manager in these trying times has been the greatest honor of my life. Mr. Chairman, committee members, I submit to you the deposition, the complaint, and all the documents I spoke about today into the official record, and I will yield the floor to take your questions.
Thank you for your testimony. There's a lot here to uncover. I think the burning of documents kind of grabbed everyone's attention because it just looks really bad, and it is bad. However, whether you're burning documents or putting them through a shredder or just throwing them away, it doesn't matter. Things are being destroyed. And in the process, we're also seeing an issue with the appeals issue. So there's a number of things I want to go through here, but I'm going to let committee members go first. So that Representative O'Malley.
Thank you, Mr. Chair. I appreciate that. Well, one thing is obvious to me today, and that is Mr. Hartman picked the wrong city to pick on. I congratulate you on this. I'm sorry that you had to go through it. And the other thought I have, and I do have a couple quick questions. The other thought I have is Port Huron was in a position to take these guys on. There were a lot of small businesses that may have succumbed to these types of tactics because they didn't have the $15,000 to handle all of this. So you didn't just stand up for the employees at Port Huron. You're standing up for a lot of small businesses out there that have had these same types of things. So again, thank you for that. Do you happen to know what Mr. Hartman's current employment status is?
The first part of your comments, I want to be very clear with the committee here. I was hesitant to come today.
I respect that.
I'm not looking for a fight. We were never looking for a fight. Coming to Lansing to shed light on the misconduct of a state agency is pretty intimidating. We fear retaliation.
Mm-hmm.
A lot of small business owners probably don't challenge it because if you challenge my OSHA, what will happen? So I want to be very clear, and although I appreciate your sentiment, I never sought out to fight the system and to set an example. I just wanted to clear the names of our hardworking employees who were literally delivering core public services during the middle of a global pandemic when a vast majority of our residents were working from home. They did not have the luxury to do that. As for the internal workings of my OSHA, I don't keep tabs on what Mr. Hartman's doing.
Yeah, well, I want to find out because that's interesting. But sometimes you're not looking for a fight, but a fight arrives on your doorstep. So I appreciate you being here.
With Representative, if I could just add as well, I don't fault Mr. Hartman completely.
Mm-hmm.
The destruction of notes and emails, that was coming from his superiors. He testified under oath. That's not something he did arbitrarily. I've been a city manager for 13 years. I have never emailed a staffer and told them to destroy documents. What was the motive of that? What is the point of destroying documents before due process? And it's not just in the Port Huron case. This is after all their cases. They go back and destroy emails and documents regarding the case.
True, but my observation is that he didn't even have to file this complaint. He could have walked out, as you said, everything's fine. He chose not to. Do you happen to know who authorized that press release from the Emergency Operations Center?
I have no idea, but there was never a statewide press release issued when the case was dismissed, I can tell you that.
Yeah. See, I have problems, along with my OSHA, with our emergency management system, but that's a whole nother argument on a whole different day.
Well, Representative, if I could add to that, I don't want this press release to reflect on the Michigan State Police. I work with the Michigan State Police. They are some of the most respectable, professional, high standards folks to encounter with. So I don't believe that this is a reflection on that agency.
No, but maybe on that department. Okay, that's all for now. Go for it. Thank you.
All right. Representative Yarrick.
One bit is housekeeping. There was a number of items that we've been provided, but you said you have other things that you're going to submit. Is it possible to get those now so we can review those? You said you have some other emails. I think that may be helpful in regarding further testimony. So can we, because I have the, some administrative hearings, the rules, that document, but some of the other emails you alluded to, you said you're going to submit it to the committee. Can we get those now to review? Can we?
And for the committee's knowledge, this is going to be a multi-week process.
Okay.
I think next week we're going to have another hearing regarding some IOSHA issues, but we'll try to get you those copies.
The other thing is that you raised that Mr. Hartman got this direction from his leadership, and this is an organizational issue. I just want to make sure I'm not missing this. Is the evidence that you're citing is his testimony on page 16 that this was policy?
It's on, there's several points within the deposition, page 16 and page 17, and also page 157, where he said he was following policy and that he received an email directing him to delete them.
And did he, and I probably will go to that, do you happen to know, and I'm going to try to get to that page, who directed him? And I realize that's in department, but I wonder in this deposition, because I'm trying to find
somebody who had the authority to direct him.
So I guess, I guess trying to get also to the bottom, is this related to his supervisor? And again, may not be something you can answer, but I'm looking, because you're suggesting it comes from leadership, whether this is an issue of his supervisor, and although you can't answer, I want to get to that point with the department. Is the supervisor had set this policy, told him, or does this go all the way up, to the director of Leo, this flow down? So you may not have the evidence, but you have the deposition. So when you say this is a problem with leadership, this may stop at a supervisor, or a supervisor not interpreting things correctly.
Those are excellent questions, and I am not in a position to answer them. That's way above my pay grade. I will say, what was frustrating is as we're going through the due process, I'm holding in my hand the depositions that say that guidance emails and general guidance emails were being deleted, and yet at the same time, Director Bart Pickleman was giving public statements that, no, these are duplicates and non-essential documents, and so that's clearly not the case. It's sworn testimony that it wasn't duplicates, it wasn't copies. These were emails pertinent to the case that were being destroyed. So it was very frustrating. We kind of held that. That's why I was looking forward to sharing this today, saying, no, these were not duplicates or copies. These were the only forms of these communications that were destroyed.
No, thank you. I thought, I was trying to make sure I didn't miss something in the deposition as I reviewed it and points that you were
I'm
making.
going on the assumption that someone who had the authority to give him direction to delete documents and emails.
Okay, so I think that's my biggest concern in this. If Mr. Hartman is confused on policy, it may not rise all the way up through the organization. This may be at some tier, which you're not responsible for, but I'm just reviewing the deposition. I think it's very important to make clear where we need to get to the point of where these concerns are in the organization. So thank you for coming today. I know it's difficult, and thank you for the time traveling to Lansing. Thank you.
And for the committee members' knowledge, I believe someone from MIOSHA will testify after this, so that could be a good question for them. Representative Riley.
Thank you. First off, probably a question that I'm glad you're here today. What percentage of people do you think that are affected by MIOSHA would come in here and testify like you are today?
I have no idea, but I tell you, I was hesitant. I'm the city manager of one of Michigan's largest core communities. I have a legal team the size of a small army. I was intimidated coming in here today. But I came because I do believe that there's small business owners and mom and pops who did not have the resources, who did not get a fair shake at the system. So what percentage, I'm not sure.
I would throw out there that maybe 5% of the people, maybe 1 out of 20 might be willing to come in here, just from my experience talking to people. But I had some questions about your fine. So how long of time period was that you were notified that you'd be receiving a fine after your previous occurrence with?
The inspection was on July 21st. We were informed of the fine on August 3rd via phone conference.
Is that typical that you receive a fine? Have you ever had dealings with MIOSHA before with fines?
Everyone does, yeah. Here's the thing. You got a sewer grate cover that's open, you're guilty. Pay the fine. I mean, you got a ladder that's not bungee corded to the wall, you're guilty. I think what's critically important about this case is we cannot take away the vital important work that MIOSHA does in the state of Michigan. We are a significant large manufacturing state. Those employees deserve protections. They deserve a MIOSHA that works and is effective. And so I'm not here to take away from the important work that MIOSHA does, because I believe their work is critically important in the state of Michigan. And it has been in the city of Port Huron. And before this all happened, we found MIOSHA to be quite reasonable.
Okay. And then you mentioned that they would give you a reduced fine if you paid promptly, or
yeah, they said if you essentially if you essentially admit guilt, they'll probably give you a settlement, which they did offer, $3,000, more than half the price.
Is that typical that they would do that?
Oh yeah, that's normal.
What do you think about that policy? Does that put pressure on you, or did you feel intimidated anyway when that happens to have to make?
No, I wasn't intimidated. I was more insulted. I was insulted that you came to my office, you told me you observed no violation, you told me you have no evidence of a violation, and here you're trying to, get me for $3,000. I was insulted. I wasn't intimidated.
All right. Thank you.
Representative Brixey.
Thank you, Mr. Chair. Thank you, Manager Freed, for coming and talking to us. I come from local government, so I understand the struggles that any large organization goes through. I came from Meridian Township, which has a full-time police and fire department, a community about 40,000.
A prime community.
You know our tagline, yeah. Right? So, one of the things that that I think for any members of the public who are here and watching is that we haven't really talked about, and that you haven't touched on, is that, why does MIOSHA exist? And they exist to make sure that we have safe workplaces for our very valuable frontline workers, and that when someone in your community goes into your offices, that's our job at the state, to make sure that people are operating a safe workplace. So I want to, thank you for your comments about recognizing how challenging it was for members of the public and members of your staff during the pandemic. This is something we all shared. Our offices shared this as well. I received lots of calls from workers during the pandemic that were terrified, literally for their lives. And, one of our colleagues said that MIOSHA picked the wrong city to pick on, but that really isn't how MIOSHA works. MIOSHA only came to you. It wasn't a random audit. They only came to you because people from within your organization, your very valuable organization, felt for their safety and their lives. And that's why they came to the city of Port Huron. So I just want to, make sure that we all remember why this process exists. You don't have the ladder bungee corded. That is something that could be dangerous if a person gets up on it, right? So, what you didn't address was the people who didn't feel safe within your organization. Do you do any surveys of employees to talk about worker safety?
So I'll have to show the timeline here of when the complaint was filed. It was at the same time in which I deemed some workers essential and ordered them back from furlough. For entry-level workers, they were making more on unemployment than they were if they actually came to work. There was a very small minority of my employees who didn't want to come back because they were getting a pay raise being on unemployment at the time. So coincidentally, that this complaint was filed the same time I ordered people back from furlough.
Okay, and did people have access to, were people vaccinated? Were people?
Excellent question. In fact, we're the first municipality, I believe in the state of Michigan. We had a collaborative partnership with Kroger in early April 2021 to hold on-site vaccination clinics, not just for our employees, but for their families.
Great.
And so we vaccinated more than 100 and some folks in one day, their wives, their fiancés, whoever it was, get them in the door to get them vaccinated. We were one of the first communities to deploy vaccine clinics internally.
In April of 2021?
Correct.
But these complaints came in
July.
Of 2021?
20.
Oh, of 2020. So the vaccine wasn't available to protect people at that time. And so the only means of protection for people during that time was personal protective equipment.
And Representative, it's not just that. We couldn't rely on PPE alone. That's why we spent more than $150,000 on not only microbial disinfection of the facilities, patrol cars and fire trucks. They would go in and fog the fire trucks after shift and fog the police cars after shift. We also focused on additional housekeeping as well, sanitization. We brought in crews in that their entire job was to go around and sanitize doorknobs and elevator buttons. And we spent hundreds and hundreds of thousands of dollars. We didn't want to rely on a mask alone. We wanted to rely on it was a whole comprehensive mitigation and response plan. We weren't just looking for a silver bullet.
Right. So, but back to the nature of the specific complaint that actually triggered the inspection at your fine city of Port Huron. What was the nature of the complaint?
That we didn't have a PPE, that we weren't providing PPE, which we were, that we didn't require masks, which we were, that we didn't have a response and preparedness plan, that we did. So everything in the complaint was found to be meritless.
Okay, but the complaint was about specific people not wearing masks.
Correct.
Right? It wasn't that wasn't just that no one was wearing it. It was specific people. So one of the things that we've as a body here have talked about is it's really important to provide whistleblower protection. When we're a government agency, we're big, and the people who work for us are little. And they can be very intimidated by actions that we take. And so, the very thing that you are feeling and expressing and articulating that, you're being picked on by MIOSHA, it strikes me that people within your fine organization were feeling the very same way, and that's why they made the complaint. That they weren't feeling protected. It wasn't a random audit. It was MIOSHA was responding 2 complaints from within the city of Port Huron. Now, the next part of this is that,
Representative, if I could, the inspector responded to that complaint and found no wrongdoing, testified under oath that we were complying with the rules, and that there was no merit to the claim. So anyone can make an accusation, but MIOSHA did their job and found no wrongdoing.
Okay, so you cited a bunch of documents, page 69, page 16. I didn't receive any of that to review. So I don't know if any of the things you read from are being taken out of context. And I would like to request to our chair that the chair provide all members of this committee, not just one party, with documentation that's going to be discussed at the meeting. So if there's documents that have been provided, could you please share that with the rest of us before the next meeting? So back to the complaint and the process. So you mentioned that, how long did you say you've been manager?
This will be my 8th year.
This
is going on 8 years.
8 years, okay. Congratulations. You've had a lot of challenges in that time period, and I know I've shared stories. I was a treasurer, and
To your question.
all right. You mentioned that you had had MIOSHA come to the city before.
In every municipality
Right.
I'm in, every couple of years
right.
you get a random inspection.
Okay, the random ones,
Yeah.
right, okay.
Nothing severe has ever been found.
Right. So I know that they have some kind of a fee structure where they give you a break for if it's your first offense or something like that. Did you qualify for that?
That was never made available to us. I have no idea.
Okay. I think maybe you qualified for that. You also mentioned that they would have given you a discount if you had admitted guilt. Do you know what that aspect?
No, it was just mentioned that we should explore that. Hey, if you plead guilty or admit guilt, they may give you a settlement. And they did eventually, which we rejected.
Okay. I probably will follow up with the department for those types of things. So back to the worker safety within the organization. Did you do any kind of brainstorming and feedback sessions with your staff about how to make staff feel comfortable and what types of protections you should put in place as part of your COVID plan? I know you had all the things that you're required to do, but did you have any planning sessions?
Yes, Representative, we did, and that is what derived the hundreds of thousands of dollars of mitigation measures we took to protect our employees. With the city of Port Huron, we may be a big operation, but we're a small operation in the same sense in comparison. We love the people we work with. I don't want to kill my colleagues, and they don't want to hurt their colleagues. And so there's a reason why we're the first city to bug out. There's a reason why we're the first city with a response and preparedness plan. They're the reason why we're the first city in St. Clair County to begin microbial spraying. We wanted to protect our people. Our people in the city of Port Huron is our greatest asset. We can replace patrol cars, we can replace plow trucks. We can't replace our people.
Right. And MIOSHA received complaints that people, specifically you, were not wearing masks and that they didn't feel safe. And
I offered video surveillance footage of my building, which they rejected.
And so it was alleged there was complaints. Was there just one complaint, or was it multiple complaints?
I believe it's just one.
One complaint, okay. So I kind of want to go through a lot of this. There's a lot in my mind here. For the life of me, I cannot figure out why when you offer them video surveillance, someone wouldn't take you up on that. I mean, I'm willing to bet if we went to the MIOSHA office themselves and could watch hours and hours of video surveillance there, you could probably find one guy making one mistake at one point, because everyone makes a mistake. And so if they're looking for proof, man, video's pretty good. And you're saying they had no interest in even reviewing the tape.
No, I took seriously when someone says the city manager is walking around not wearing a mask in the middle of a COVID pandemic. It's insulting. I wanted to prove my innocence and provide evidence that that did not happen.
I still can't figure that out. And so then, all right, I can understand if they say, all right, we don't need to see the video because we saw something else right here. Here it is. Here's the violation. But they never had a violation to point to.
Correct.
Instead, the word a general feeling. So they essentially were trying to convict you on a general feeling. All right, so let's run through the timeline of this. The first time you were told there's a violation is $6,300. That's the fine that they're levying, right?
Yeah, on August 3rd.
And you rightfully said, hey, this is garbage. We're not playing this game. What was your next official step that you took once they...
Our legal team put together a comprehensive appeal, a multi-page appeal on 3 different approaches I talked about, both the merits of the case, the constitutionality of the case, and the flawed legal premise in violation of the Court of Claims order, and filed an appeal on October 6th.
Okay, so they filed the appeal October 6th. Now, that appeal is within MIOSHA, right? You're not in a court yet. You're still within the agency.
MIOSHA. I felt very confident that once a supervisor pulled the case file and saw that no evidence was observed, there was no evidence, there was no violation, it clearly would be dismissed. The process should have worked. It didn't. It wasn't until the professionals at the Attorney General's office.
All right, we're going to get there here.
Okay.
So let me go through. So you filed the appeal within the agency. So just, if you step back for a second, agency says, here, we're giving you a fine. You then appeal to that same agency regarding that fine. Okay, so that's the process. You appeal to the agency. What is their next steps at that point?
They deny it, and then we begin going through requesting a hearing through the Administrative Law Procedures Act.
Okay, so they deny the appeal. Explain that denial process. Was there a hearing? Was there
No.
different? So there's no evidence being brought in before. Basically, it just goes before some bureaucrat, and they
It goes
determine.
before the supervisor. The supervisor has the appeal. I believe
Okay,
was
so it
Curtis
goes to the
Johnson.
supervisor. He says, I deny it. Then you basically appeal the denial.
Correct.
And who does that go to?
Well, we actually begin going through, that point it touches the Attorney General's office, so we're going to go to court.
Okay. Are you ever talking to an administrative law judge in this process?
Oh, yes. Our legal team was. Yes.
Okay. When you get to the Attorney General's office, you said they were professionals and they were the ones that kind of dismissed this. Can you run through that process?
So,
Because
yeah.
eventually- let me step back one. You said at one point you're offered a $3,000
That came
fine.
from MIOSHA before our appeal,
Before the first appeal or the second appeal?
before the first appeal.
All right, so this is crazy to me. You say, hey, we are fined $6,300. You say, we're not paying this, but before you actually even filed the first appeal, they already come back and say, well, you can just pay $3,000 if you want.
Yeah. So when it gets to a hearing, when you actually begin going through the Administrative Procedures Act, and you actually begin, like essentially a trial, you begin the discovery process where you issue subpoenas, you perform depositions, and you begin collecting evidence during discovery. So we were in the discovery process. After the first deposition, the single one, it became remarkably clear that this was a meritless case. The Attorney General's office quickly recognized that and moved to dismiss the case.
Did MIOSHA, Attorney General's office is representing MIOSHA at that point?
Correct.
So the state of Michigan, they start to go through facts and they say, there's nothing here, we're dismissing.
Correct.
So this started as a $6,300 fine, goes down to a $3,000 fine. You end up paying nothing to the state. Do you have an estimate of legal costs that you had to pay for all this?
Somewhere between $15,000 and $20,000.
$15,000 to $20,000. So you paid more money, about 3 times more money than had you just paid it to begin with.
I did. And the reason why is I'm not going to plead guilty and damage the professional reputations of our employees who worked very hard.
I'm glad you did. But was there ever a time where you guys sat down and said, hey, we got to make a business decision here. Is it worth it just to pay the doggone fine and be done? Did that conversation ever happen?
Of course it did. Of course it did. The question becomes there was statewide press releases issued. I had colleagues texting me, like, what are you doing? Get your house in order. It was embarrassing. The local press did a front page breaking news alert pinging people's phones. City of Port Huron violated the rules. It was humiliating. It was degrading to our professional reputations when we did nothing wrong. And on top of that, this wasn't just like a regular MIOSHA visit. This was in the middle of a global pandemic. Our employees were going through remarkable circumstances. Again, sleeping in campers and in their garage and pole barns to separate themselves from the dangers at work to their families. We're not going to plead guilty to something we didn't do.
I'm glad you didn't. But now imagine for a second that you're a small business owner and you've got to worry about a profit to be made. In your opinion, if there's a small business owner facing this same exact scenario, wouldn't it make sense that they're probably saying, just pay the fine and be done with it?
Mr. Chairman, I respect the question, but I want to limit my editorializing on this issue as, again,
That's fair enough.
I'm an
I
administrative
appreciate
employee.
that. I will editorialize
I'm not a
here.
politician. I'm not here to provide my editorial comments on the state as a whole.
All right, I'll editorialize here. I think every one of us here in this committee can admit, if you're a business owner and you're being faced with, you pay $6,000 and you just pay the fine even though you know you're innocent, or you pay $20,000 with some hope that you actually win. And by the way, had it not been dismissed so quickly by the AG's office, it could have ramped up to more if you would have gone to court. 90-some% of business owners are going to say, I'll just pay it. That's what's going to happen. In your opinion, should we maybe have a loser pays model when we talk about this, so that way if a business or a municipality decides to appeal something, and if they win, the state would have to pay their legal costs?
That's an excellent question for a duly elected official, not an administrator.
I appreciate your answer for that. I have more, but we'll keep things going here. Representative Young.
Thank you, Mr. Chair. Thank you for being here today.
Thank you.
I just had a question, because the thing that always matters to me is people capital, like you said, is the most important. And so when we look at this one person, because now I think it's been determined that it was just one complaint that went to.
We believe so.
Okay, all right. I know that just for us that are part of this committee, that one voice, our one voice can represent tens of thousands. So we just know it was one person. But I'm curious about how you all handle complaints, because it seems, you know, a big deal to have to go outside of your workplace straight to MIOSHA. Did you get complaints? Do you have a history of complaints?
It's actually pretty simple. You can just Google and file it anonymously on their website.
But did you get complaints prior to about concerns and then?
We didn't get complaints, but we had to explain to the staff exactly what we were doing to make them safe. So as they come back, we had to show them the response and preparedness plan, demonstrate the measures we have taken so that they could come back in a safe manner. We also want to note that at that time, we had no employee-to-employee transmission of COVID-19 within our organization. We still did not know, but it was more than a year later where we think maybe we had one case of employee-to-employee transmission. So for more than a year and a half in the pandemic, we did not have a single case of an employee-to-employee transmission, which is testament to our mitigation measures we had in place.
That's great work. You're right.
And we case tracked that. Remember, we were tracking cases and where did you become exposed? Who were your close contacts? We sent employees home who may have been. Most of the people who went home with COVID or exposure happened outside of work.
Mm-hmm. Okay, so having gone through this, and clearly the appeal process worked. So we're glad that something's working, right? So we're glad. I know you had to pay, but it worked. So then now you're here. One of our jobs is to make things better. So. Would you recommend that moving forward, the department keep handwritten notes? I'm always looking forward to resolutions and how we help fix things. So what would be some recommendations from you, having just experienced this, so that we can be better?
Yeah, first and foremost, I was a little bit disappointed in the media coverage on the burning of documents. I thought it was unfair to make it a political thing. Disposal of handwritten notes, that I don't find. I mean, it would have been nice to have them. The most egregious one is the destruction of emails with communications with supervisors. That's the point that has my attention. Mm-hmm. As for recommendations, we have policies in place. LARA has a very excellent records retention policy. It's just not being followed.
Okay, so internally, we just have work to do, which happens in any organization. So.
Oh, 100%.
Right,
Here's the fact. Right now, I have 400 employees. There could be someone right now whitewashing a server, and until that comes to light, I wouldn't know about it. And so the issue is not that a problem happened. The issue is now's the time to correct the problem.
And that's what we want to do.
And I look forward to working with you and the committee on that.
Thank you. Representative Hoytinga.
Thank you, and thank you for being here. You've been very articulate and very professional, and there is no doubt in my mind that you did 100% of what you could do to navigate through the COVID and to keep your employees safe. I can just tell by your professionalism and how you've articulated this whole fiasco. I am highly confident you did everything you could possibly do. Just with that said, it just sounded a little offensive, the questions that were coming from the other side over there.
They were fair questions.
But it brings me back to the due process question. So the work in the people in small businesses in my district, when my OSHA came in and fined them, they gave them like an itemized fine, where yours itemized like you didn't have masks, or you didn't do this, or you didn't do that. And so they had actually a fine, right? I saw the actual MyOSHA tickets.
They couldn't do that because MyOSHA failed to properly follow the Administrative Procedure Act and promulgate emergency rules that would have outlined those fines. Right. But because MyOSHA failed to follow the law, they had to just put it under generic general duty.
So that makes just absolutely no sense to me, because the MyOSHA fines that I've seen on my businesses that seemed really unfair, they literally, if there wasn't a handbook inside one of their trucks, they got fined for each truck, and then there was an amount next to it. So I am just completely confused about where this figure of $6,000, where it came from. It just came out of air, or I'm just, all right, thank you.
Representative LeGrand.
Thank you, Mr. Chair, and thank you for coming in and testifying. I know it's not great to have these like 8-foot-tall chairs between
No,
us.
I was just thinking that.
I don't know, we're maybe expecting a contingency of giant staffers, but maybe we could get somebody with a hacksaw to lower the height of these things one of these days. That might be a MyOSHA violation, though. Probably give us some ragged edges. So I appreciate your coming in, and I appreciate your overview, and I do not want to minimize, the frustration that you experienced in this. And I do, however, want to point out since we're in an oversight committee here, and we should be talking about policy, there's a old axiom in my space, in the legal space, which is that bad cases make bad law. And so I want the committee to be cognizant of the fact that, there are a lot of things that they got screwed up here. But the question is, how do you build a better mousetrap, and is a bad case a proof that you need to fix your mousetrap, right? So the fact that it sounds like you had an anonymous person essentially making unfounded allegations, well, we can't fix the world for that, right? I mean, you could walk out of here right now, call state police and say that you saw LeGrand sitting at his desk packaging up anthrax. I can't stop you saying that, right? And so unfounded allegations are just things that can happen in life, right?
But Representative, if I
Sure.
could pause you, I think Representative Brixey and Young bring up a very good point, that there needs to be whistleblower process in place, because this was an unfounded accusation. But it doesn't mean there aren't legitimate issues around the state that need to be investigated, and those voices need to have a pathway to do that. So I think that can't be diminished. I think the representatives bring up a fair point.
Yeah, absolutely, and I didn't mean to suggest that you were suggesting that there was something wrong with the ability of people to come forward and make accusations. Then you have the ability to do exactly what you did, which is say, go to the tapes, right? Where's the evidence? My concern is, just in broad overview terms, and you work in government in general, things like, MyOSHA is following a process here which looks a lot like other processes we do in government, and I tend to think that they're probably the appropriate and the best we can do in some steps. So let's just talk through. I just want to be clear about the narrative that, like, the Attorney General came in here and, like a white horse, rode in their white horse and dismissed the case. Well, that's roughly what's supposed to happen, right? Anytime you have an agency, whether it's, you do property tax assessments in your district, right?
Yeah.
I just got what looked to me like a hallucinogenic assessment of property I purchased. Like, it was the assessor just said that the property was worth $200,000 more than what I had paid for it 2 months earlier in an arm's length transaction, and $200,000 more than the previous SEV. And I wrote them a note and said, hey, A doesn't seem to imply B here, but I did that. I had to do an internal review there. Now, most of the time, most agencies will try to defend, just like I will try to defend most of my decisions, right? So agencies will inherently have a an instinct to sort of try to ratify the decisions they made, right? Like they don't want to say, yes, I don't know what we were thinking. I hadn't had enough coffee this morning. I screwed up. So I fully expect in that appeal process, what I'm going to get is an internal rejection of my appeal, and then I'm going to have to go to the next step. And that's, just so we're clear here, that's essentially what happened with you, right? Like there was a person on the ground who looks like they didn't follow logic or evidence in terms of the allegations against you. And then the agency itself had a very quick, probably no lawyers involved, smell test review, because that's where they're supposed to screen out the things that smell really bad. And for whatever reason, yours didn't smell bad enough to get rejected. It got referred to the next stage where you had to litigate it, correct?
What was odd is in the deposition, the inspector so you appeal, so there's a supervisor who gets this appeal, and we're essentially saying, this is meritless, there's no evidence. You would assumed that Curtis Johnson would have reached out to his inspector on the ground and said, okay, the city of Port Huron says that you found no evidence, that you said you had no evidence. Can you tell me about that? But he testified under oath that he never had a conversation with Curtis Johnson about this. So was our appeal ever even reviewed fairly?
I get it. What I'm suggesting is that review model is baked into just about everything we do in government, right? It's baked into a property
You have to have
tax
internal,
appeals.
yeah, you have to have internal checks and balances, whether it's your board of review, your construction board of appeals.
Right.
Administrative officials make mistakes.
Well, again, so what we're saying here is essentially we had 2 layers of mistakes. Now, that's not the same thing as saying the entire system is wrong, it was a bad idea, and we shouldn't do things that way, right? So I guess if this group is not wasting its time reviewing one case that didn't work right and a couple people who didn't do their jobs right, I mean, I make mistakes all the time, right? You multiply it out over an entity, you're going to have a lot of mistakes made. The question is whether the mistake should be the thing that changes your rule. And respectfully, Mr. Chair, like we could have an interesting seminar on loser pays models. The problem with loser pay models is that people with deep pockets tend to be able to move things. They can produce exactly the problem that I think a lot of our committee members have been worried about, which is big people can throw their weight around more easily than small people. So, you know, there was a horrible case when I was a kid. There was some defoliant being used in Cape Breton because I grew up in Nova Scotia. Big chemical company was able to like litigate the thing forever against the homeowners who were in the area. They lost, and then they all lost their homes for having to litigate on this defoliant, which was banned everywhere except in Nova Scotia. Like, can't use it in North America, can't use it in Sweden, where the company was from. They lost. Now, even if they were supposed to have lost, I'm not sure that in a loser pay system, then those little people have to pay the law bills for the big lawyers that are on the other side for the environmental. I mean, for the sprayers. So you got a deep pocket problem anytime you do a loser pay model. So I think there are, I mean, in America, we don't use a loser pay model for personal injury, for example, because otherwise you wind up with all of those problems. So we could have a seminar about this, and we could talk about moving to a loser pay model, but there's no free lunch there. It's a question of incentives, disincentives, the ability to bring things forward. And in America, generally, we have said we like more things to percolate up. We like people to have more opportunities to have their day in court, and a loser pay system actually tends to repress that. So I just wanted to, like, I guess what I want to get at here is what recommendations, having gone through a bad case, do you have thoughts on how, if there are lessons from a bad case that could apply to this process systemically? Because obviously you had the AG.
Representative, your dialogue is very interesting, and it's good dialogue.
Here for, right?
That's what you're here for. I'm not elected, and these are great questions for elected officials. I just want to separate. I am an administrator. I'm not going to jump into policy discussions that are not appropriate for someone who wasn't elected to be here today.
Well, but I mean, respectfully, if you're here to tell us about your bad case, I get it, right?
I don't want to talk about potential legislative
He's here to highlight
solutions.
the issue. It's our job to say, here's an issue that we can fix. What's the best way to fix it? Because I know as city managers, you guys are not allowed, I think, legally to be political.
Ethically, we don't get into political discussions. And when you start talking about policy solutions, stuff like that. It's fascinating to listen to, but it's more appropriate for the elected officials to engage in that.
Well, I guess then I'd flip it around and ask, why are we here then? We're not just here to talk about one bad case.
Well, we're going to have the discussion as a committee. And so I'm happy to have it. So in response to your regard of, hey, we shouldn't make law on one bad case, I agree. There's more than one. Next week, we're going to hear another case on this. And I assure you, there's a lot of business owners out there that have the same thing, but they're afraid to come forward. Because they'll tell me behind the scenes, you know, if I come forward, I'm pretty sure all of a sudden they're going to find excuses to come to my workplace and ding me. They're afraid of the government agency here. With regards to loser pay, which I think is a good idea, you said the problem is a big pockets problem. We already have that problem. You're going against the state. You're a little business, and the state says, we think you made a mistake, and they say, we actually didn't. We're going to fight you on this one. The state has essentially unlimited resources compared to a small business. And that's what we're seeing in a lot of these cases is they say, I just can't keep fighting this. And you're going to hear next week of a business that keeps winning, but they keep being appealed over and over again. And they're, I think, now spent over $100,000 fighting a fine of just a couple thousand. Go ahead.
Yeah, respectfully, Mr. Chair, my concern is that essentially you'd be giving the big player even more power. So if you say loser pays, then somebody appeals an OSHA decision, and then OSHA comes back and says, no, we do have pictures of the bungee cord not on your ladder. And then OSHA gets to, my OSHA gets to say, well, and we had to put $100,000 worth of staff time into this decision, so now you, ladder owner, owe us $100,000 for our staff time. I mean, the problem is if a loser pay system means the loser pays, and if the loser is the citizen, then all of a sudden we're putting huge costs on citizens for fighting my OSHA cases. So I think it might, I mean, I think potentially it blows up in your face, and you wind up with a worse problem.
So what if we do a myosha pays if they lose scenario? I mean, that's one that we're trying to make sure that they don't just assume, hey, I can always fight this person forever and ever, and there's no ramifications. Because there's ramifications for the small business, and that's what we're seeing, and we'll hear more next week on this. So there's more things there. But I want to continue, since you're here, I want to ask you a couple more questions. And I know a couple things. So first off, one of the things that's going to be brought forward is, well, the documents being destroyed, they're duplicates, they're not necessary, we have everything we need in the case file. It's your contention that that's not the case. Can you make that very clear exactly what your contention is regarding that?
The inspector said the emails were general guidance on how to proceed with the case. And then he said he got an email from someone who can direct him to destroy, and this is not an isolated case, but this is after every time a citation is issued, to destroy all communication. So imagine it's a city manager, I have a records retention policy I have to follow. Imagine if I say, okay, everything that's in this binder, that's case file. All the voluminous work that went into building this case file, though, I deem it as not in the case file. Therefore, it's not retained. It's not in the spirit of records retention or our sunshine laws in the state of Michigan.
And you just thinking from an incentive perspective, if you're the caseworker on this, you're going to put the stuff in the case file that helps your case. And anything added that you might not think is actually valuable to it, yeah, that doesn't maybe perhaps get in there, and now that gets destroyed, and when it comes time for the appeal, that extra information could be incredibly valuable instead of just the information the caseworker kept.
In any investigation we do within the city of Port Huron, all evidence, whether it helps the defendant or the prosecution, exculpatory evidence must be made available.
Getting back to the general duty clause, it appears that that's where the violations were coming from. There's this dispute between executive orders, CDC guidance, OSHA. It seemed that the executive orders were what were being referenced in the communications between MyOSHA and you, which were later deemed to be unconstitutional. Can you explain about the court decision saying those EOs couldn't be used prior to this occurring?
There was a lawsuit that was the Court of Claims issued a order on in late June that says MyOSHA cannot treat a violation of the executive orders as a violation of general duty. If they wish to do so, they need to promulgate those rules, emergency rules under the Administrative Procedures Act. That was not done. So the citation that was issued to the city of Port Huron was in contrast to the court order by the Court of Claims in late June.
Okay. And once again, just to be very clear, there was no actual specific allegation made against you that they could prove. It was a general feeling. I know I was told about they didn't have an itemized breakdown of here are your violations and here's where the fine is. There was never anything specific to fine you on. It was a general feeling.
Sworn statement under oath, they observed no evidence and no wrongdoing.
and yet you still received a fine.
It's a general feeling.
Okay. Any other questions? Rep. LeGrand.
So just to follow up on our earlier exchange, I think potentially what we're talking about is a fines and costs mechanism, and I think that's certainly something that might be appropriate to explore, because you can have a reasonable fines and cost mechanism, in which case, you know, the city could have recovered here the $15,000 or so they paid on legal fees, at least reasonably, if there was a showing of no finding and a complete dismissal at the upper level. So I think that's something worth considering, but I wouldn't call it a loser pays mechanism.
Fair enough. Anyone else? All right, Mr. Freed, thank you.
Mr. Chairman, if I could, before I go, I do want to take a moment. When you challenge a state agency and you talk about a state agency, we must take a moment that there are thousands and thousands of hardworking state employees throughout LARA, throughout MIOSHA, throughout the DOT, throughout the Michigan State Police. Every organization has bad apples. I do not want this to reflect on the state employees as a whole who tirelessly come to work, also through the pandemic, to ensure state services were delivered to our residents in the state of Michigan. I applaud the state employees for their hard work, for the dedication to the state of Michigan, and we cannot take an isolated case and try to show reflection on all those hardworking employees, and so I just want to make that note. I appreciate your time to come and present, and I'm going to try to beat the wintry mix back home to Port Huron.
Thank you. All right, so it was our intention to next have my OSHA director up, but we only have a few minutes left, and my guess is we're going to have a lot of questions. So I think it might actually be best to hold that to next week if you're okay with that. We're not going to have enough time to get through all the questions. We've got to leave about 3 minutes here. So we'll work with my OSHA on trying to find time to make this work. I'm sure we can make this work. It wouldn't be of any value to bring you up just immediately adjourn
It would
committee.
be of value
So-
to me to get 4 minutes from the director.
With that, we'll be back next week with more discussion regarding my OSHA. Thank you. Seeing no further business for the committee, we are adjourned.